Good afternoon and a very warm welcome to today's webinar on mediation process and career opportunities. Thank you all for taking your time out and being here today. I'm Yadav, and on the behalf of Social Curate team, I would like to thank all the guests present and the attendees for gracing this webinar with their presence. Team Social Cure is a non-governmental organization working on the motto "Be the change, bring the change." In this regard, the team regularly take awareness sessions and organizes motivational talks, conscious seminar with regard to various social issues prevalent in the society, especially dealing with environment and women empowerment. A little housekeeping before we get started. We are going live, and if you have any questions during the presentation, please type them into the comment box. I will bring them up at the end. I humbly request all the participants to refrain themselves from typing anything but questions. Without any further ado, I would like to introduce our speaker for today's webinar. It is my privilege to introduce our speaker of this afternoon, who has done her undergraduation with a specialization in IPR from Amity, Noida. She then, I'm sorry, ma'am. She then went to practice in Indore High Court. Then she did her master's in Hidayatullah National Law University, Raipur. She is currently practicing in Delhi High Court and Honorable Supreme Court dealing with the matter of civil. At times, at times she also acts as a member of Singapore International Arbitration Center and a council member at Women Indian Chamber. She has also acted as a family counselor and POSH consultant. With this, please welcome Advocate Smeeksha Pandey. We welcome you, ma'am. With
Thank
this,
you.
thank you so much, ma'am. With this, I would like to give a gist about the webinar. The webinar is organized to make it clear how effective mediation can be and how vast is the area of interest. And the student can also look for the career in mediation. Today we have our guest speaker, Advocate Smeeksha Pandey. She will be sharing her expert opinion on the topic mediation. Ma'am, you may please start your address.
Okay, so first, starting with a brief background on the topic and why we have chosen this topic today. So, since we are aware that the last 1 year, that is the last year's March till today, it will be 1 year, that there is not been very heavy litigation. So, the field, which was an alternative dispute resolution, now is becoming a parallel field, which is parallel to litigation, and people are going towards alternative dispute resolutions more after the pandemic has hit the world, because litigation has taken a backseat because of there is no physical hearing, there is virtual hearing, so the sometimes the setup is in such a way that people don't find it very comfortable, or they are not well aware about the virtual proceedings of the court. So obviously, since the last 6 months, which has seen a tremendous decline in litigation, so the alternative dispute resolution have taken a front seat, and people are moving and trying to learn more about these alternative dispute resolutions, that is mediation, conciliation, negotiation, and all the various lok adalats. So these have come as a very prominent upcoming fields in the present scenario. And that's why it is very important for us to have a background and to understand, because if you go towards an alternative dispute resolution, you will see that mediation is an informal method, and knowing about it and being aware about your rights and going towards mediation can help in a lot of manners, and it can save, not only save your time but also your money and various other resources which you normally utilize for litigation. So, coming to mediation, I have seen that India is a very family oriented country, and family is a very important unit of the country. And you know that there are so many backlog of cases already. So, according to me, the first place where the mediation should be the first step of any legal procedure is family matters. Because if you see that the family matters are not legal conflicting matters, they have the heat of the moment, they have emotions involved, they have relations involved. So going directly towards the litigation not only hampers the family unit, the unit of family, the relationships, but it also somewhere add up to the backlog. So, according to me, whenever there is a family matter, it has to first go to an alternative dispute resolution so that it provides a cooling period to the family members. It provides a period where they can think about the conflict, because obviously in the heat of the situation everybody has a right to act and react, but then both the members need a cooling period to analyze, to think, to know that okay, what was wrong within the situation and what was wrong in their action or reaction. So I think if we will take mediation as a first step in family matters, then it will act as a boon to those cases. And similarly, if you go towards the trademark cases, you see that big giant companies are suing small companies for just using their deceptively similar symbols or a certain kind of music or sound or anything. So when it comes to trademark cases and family matters, I think mediation should be made the first step, because obviously, as we are talking about right now, that we have to be vocal for local. So how will local market grow if they are not allowed some feasible path to for themselves? So keeping these two areas in mind, we will be discussing that how mediation works individually and how mediation can be proved a boon to these two fields. So let's start. What is mediation? In layman terms, the term mediation broadly refers to any instance in which a third party helps others reach an agreement. More specifically, mediation has a structure, timetable, and dynamics that ordinary negotiation lacks. The process is private, confidential, and enforced by law. Participation is voluntary. So, see, if you see this layman term, it has compared mediation with negotiation. Now, if you see the process of negotiation, it is equally informal as mediation. But there, what happens that the party comes with a motive to have an economic benefit, negotiate on certain issue. Like, for example, I'm a consumer. I'm giving this example for negotiation. I'm a consumer. I have taken some goods. Those goods didn't turn out well the way I had thought, or they were not as per the description. Now, I can go to the consumer forum, but if I choose to go for negotiation to save my time, then I will be willing that okay, if the good cannot be replaced, then I will take a certain amount plus interest. That is the money which I have uh, set aside or spent on its repairment, maybe, or maybe filing a case or anything. So this is how negotiation works. There is not a straight jacket formula for negotiation. It differs from the facts and situation to situation. I give you one more example for negotiation. That, for example, there was an athlete who was training in a gym. Now, due to the faulty equipments and faulty exercising machine, he fell and maybe he got paralyzed. Now, in such a cases, he can go to the court, but then obviously litigation take its own due time and procedure. But in on the other hand, if he goes for negotiation, for the process of negotiation, now why I am not asking him to go for mediation? Because in mediation, he has to settle down and he might or might not get the money. But if he goes into negotiation, he can claim money. Now, I'm not saying that mediation doesn't work in the process where you want to get some return or some damages done, but negotiation is more inclined towards getting those kind of economic damages which you are claiming. So in negotiation, if he is demanding 2 crores or anything, then the parties can decide that okay, the gym can be giving him a job since he is an experienced athlete at the end of the day, plus some compensation for whatever mishap he had suffered. So mediation and negotiation both are informal, but they both work for different manners and for different facts. So you have to choose that what suits best to your case. So with this, let's go ahead. As per mediation and conciliation rules, mediation shall means voluntary and confidential process of facilitated negotiation where a neutral third party known as a mediator assists parties in to reach a mutually acceptable settlement to their disputes. The role of the mediator may be facilitative, evaluative, or transformative. However, only the parties shall have the right to mutually decide the final terms on which the dispute is settled. Now, what happens when we go for mediation? We go with the motive that we want an out of court settlement in an informal manner, that is, in a friendly manner. And that's why I suggest that it is very helpful for family matters. So, when mediation is taking place, so what is the current procedure? That you file a case in the family court, and then the family court refers the case to the mediation, which I think somewhere hampers the credentiality of the family case at the initial stage, only because once I have filed a case against any of my family member, then I don't think that they will be willing to solve it out with me in mediation. So, but if there is a heated argument or a fight and I go to mediation, then on the contrary, both of the parties, that is me and my family member, will be getting a cooling period where we can decide that okay, do we really want to file a case in this manner, is in this matter, or we can solve it out in mediation. So making a mediation a second stage in family matters is not that helpful. I give you one more example for this. That recently I was dealing with a family matter, and it was filed in the year 1996. Okay, that it is such a such an old family matter, and till 2019, that is last till last year it was going on, in which the husband wanted divorce and the wife didn't wanted divorce. Now, can you imagine where the parties are not falling on the same page? Then litigation also go for unlimited time. I mean, wife will never be signing the divorce papers. Husband will be always fighting in the court. But then so much time, so much resources, so much money of both the parties, plus their emotions, everything is being wasted because both the parties want very different things. Now they have been being referred to mediation since 1996. But since once the case has been filed and they have already fought in the court, then things became so dirty, and the issue raised so much that they are never be able to come on the same page to solve the issue. In such cases, and keeping in mind the complexity of situations in family matters, mediation should be the first stage. So, and I will also talk about the role of the mediator here, that the mediator is a very neutral third party who is hearing the case for the first time from both the parties. Because if you go to the mediation room, you will see that the parties are made to sit first and then the lawyers sit behind them. This is because it is a party centric process. And here the lawyers don't have major role to play except for giving the legal advices to their party. So just to make sure that the parties are not resolving it on an unbeneficial method, or in an point where they are not benefited. For example, if you see in litigation, lawyers play major role. They sometimes even guide or dictate parties to the extent that what they have to say in the court. And these kind of legal tactics and these kind of legal procedures made the case more complex. For example, you want to keep it low, but your lawyer wants that you should charge the other party, that he should charge her husband in a certain way just to win the case, then obviously it will make it a dirty scene. So litigation works in a different way, mediation works in a different way. And when we are discussing the family matters, then it has to be first given a cooling period. Let's go ahead. What are the principles of mediation? Mediation is party centric process. As I already mentioned before, that the parties are given preferences. They come, we hear individually first from the parties that what they have to say, and then we make the parties sit in front of each other so that they can discuss. And for example, party A told me something and they said that okay, you don't tell this to party B until I tell you to tell them. So I will be keeping it confidential till the time I don't get an approval from party A to tell that same fact to party B. So the third member, that is the mediator, plays a very neutral role. And however, if in any case the mediator already knows one of the parties, then he has, or he or she has to back out, uh, telling that okay, they already know one of the parties, so they won't be able to act as a mediator in this process. So the process and the court make sure that the mediator is a very neutral person, and whatever you share with the mediator in the mediation room cannot be used as an evidence in the courtroom. So whatever is shared or being said in the mediation room remains in the mediation room. It is a voluntary process. Now what happens that at present the procedure is such that once it is in the litigation, then it is referred to mediation, any of the cases. Private mediation, though, is a very good career option, but it is not that prevalent in India, because you will hardly see any private mediation happening, or any lawyers who are taking up private mediation as their career opportunity. So it has a very good scope, but it is very new, and it foreign countries are very prevalently practicing private mediation, but our country is still lagging behind in this. It is an informal proceedings, that whenever you feel or either of the party feels that okay, mediation is not working and they will be fighting it in the litigation only, so they can ask the court to stop the reference to mediation, and they can go back to the litigation fighting for it. Mediator does not have any authority. Mediator only guides the process, and he does not decide for the parties. Parties themselves decide. For example, I gave an example that the husband wanted the divorce, wife does not wanted the divorce. So when they come to mediation, I can guide the process in a way that okay, husband agrees to give a more amount of compensation or maintenance to wife, and I can convince wife, try to convince wife that okay, he is looking ahead to life without you. He already has his life of which you cannot become a part, and obviously no one can force anyone to be with them. So I can convince or try to convince wife that okay, take a decent amount of maintenance and go ahead with life in the most comfortable and decent way you want to. It is a confidential process. As I said, that anything which is said in the mediation room or anything which is shared with the mediator does not go to the court in any way. Even mediator cannot give any evidence or proof in the court because it will be nullified. It is a neutral process. Mediator acts as a neutral person who does not know the party, who just sits there and guide the process and help to maintain a friendly environment. Mediator is not a judge. Let's go ahead. The solution or settlement terms are decided by the parties themselves. For example, I just now told that I can guide the husband and wife to be a bit flexible and come to a neutral point, so that at least there can be any scope for settlement or solving the issue. Because if this fight is continuing in litigation also, then also there will be no end, because wife doesn't want to give divorce. But in a friendly environment, in a cooling down period, if you tell her that okay, she should think other ways to solve the same issue, then she might agree to. Mediator guides the process to arrive into it. This process of guiding husband and wife is only the process that I can help them to think out of the box and don't be so rigid about their problems. Mediator acts as a neutral third party and facilitates rather than direct the process. cordial and win-win situation. It is an inexpensive process because the court referred mediation is a free process. You don't have to pay anything in that. Less time consuming as compared to litigation. Let's go ahead. There are two types of mediation, that is court referred mediation, section 89 Code of Civil Procedure 1908, and private mediation. I have already mentioned that private mediation though is an open field, but it is still not well developed in India. Family mediation is a process which assists separating and divorcing couples to resolve their disputes and negotiate their own agreed decisions in a dignified and fair way, taking in account of the needs of all involved, including especially but not only where there are children. The matter to be resolved can include financial and property issues and future arrangements of children. Role of lawyer counselors in family courts restricts the role of lawyers as it is a party centric process, so lawyers don't have a very prominent role to play in this because litigation involves a lot of tactics and preparation from the side of lawyers also, but mediation lacks that. So it restricts the role of lawyers and enhances the use of counselors in the dispute resolution to encourage mutually amicable settlements. Family Courts Act limits the role of the lawyers as legal experts or amicus curiae who the courts may consult for opinion for the parties. The act does away with lawyers with the hope to prevent excessive litigation costs, corruption, manipulation, and submissive tactics, extends and bitter court battles, and refusal to settle or compromise. The role of the counselors is limited to the task of ascertaining if the dispute can be reconciled, and even this not beyond the preliminary stage and not in the actual trial of the case. Some states uses non-governmental organizations as counselors, other use trained personal individual volunteers as well. For example, Delhi High Court appoints lawyers as mediators in the mediation center. Now, in order to be an appointed mediator by the court, you have to have 10 years of experience in litigation and 48 hours of training in this. Let's see the duties of a mediator. He summarizes, restates, and prioritizes issues. Since if you see that if litigation has extended more than needed, then you will see that somewhere the major issues which were there in the beginning have taken a backseat, and more issues have developed because every time you file an application, then you get a reply, and the issues keep stretching. So mediator somewhere tries to summarize the entire problem into bullet points, that what are the major issues which have long lost in the process of litigation. He assists in the generation of clarification of options, that okay, if these A, B, C are the issues, then what possible ways are out of these issues. He serves as neutral facilitator. He enforces the ground rules that the parties have to keep calm, and if they have the intention to solve the issue, then only they should come to further mediation. Otherwise, they can go ahead with the litigation process. He evaluates options and possible consequences. He identifies areas of mutual interest. Let's go ahead. Counselors and gender neutrality. I have intentionally included this gender neutrality part because sometimes there are lady mediators, and if you are not gender neutral in approach in life, then you might give more importance to the female if there is a family matter, which is not a very good sign, and then this won't lead to mediation. In order to be a good mediator or being able to solve the problem of two parties, you have to think above gender, because it not always that bad happens to women, and it not always that bad happens to man. So you have to really focus on that particular case which is standing in front of you, and you cannot generalize the problem of the country because you are not a politician at that time, you are a mediator. So you have to be very gender neutral in such roles. So counselors should be trained with gender sensitivity, as the neutral stand of counselor is an important attribute for understanding both the genders and drawing a settlement between them. Family issues are nuances and have legal complexities. Gender sensitivity may help counselors to not merely take neutral positions but consider the unequal power relationships between men and women in reconciliation and settlement process. The family justice system as a whole is that a conceptual basis of gender justice. Custody and guardianship of a minor child. A guardian is a person who has rights and duties with respect to the care and control of minors, a person who has not completed the age of 18 years. Person in relation or property, that is of estate or wealth of minor. These rights include right to determine the child's upbringing in regard to religion, education, and disposal of his share of property, etc. Let's go ahead. A guardian is vested with the duty to act for the welfare of the minor. The welfare of the child is paramount consideration for the court in matters pertaining to custody and guardianship of the child. The Guardian and Wards Act 1890 was passed. This act has authorized the court to appoint guardian for a minor child. The Hindu Minority and Guardianship Act was enacted in 1956. This act has codified the law relating to custody and guardianship of children belonging to Hindu community. There are two types of guardians, that is de jure guardian that have an authority vested by law, and de facto guardian that is exercising power without being legally established. Pros of mediation in family matters. The mediation process, when it improves the negotiation environment, effectively reduces monetary and non monetary cost associated with communication between the two parties. A major factor that precipitates divorce is the couple's inability to communicate without conflict. So it follows that spouses who can agree on all the terms of divorce are rare. If mediation alters the environment in which negotiation occurs, however, it can increase the probability of dispute resolution without external mandate. And what are the pros? That is, it is a cost effective method, it takes less time, it is confidential, it is in control within the control of the mediator. It helps in the compliance of the parties, mutuality, that since it is a voluntary process, the parties who are really willing to go for mediation, those parties only come to this forum and it gets an external support. So this is it with family matters. Now let's discuss in brief that what is about when it comes to trademark matters. So I think you all must be aware about what is a trademark. Uh, I have already discussed at length what is mediation. So let's just come to the part that of how it works in the cases of trademark. So, a trademark is a distinctive sign or indicator of some kind which is used by an individual, business, organization, or other legal entity to uniquely identify the source of its product or services to consumer and to distinguish its products or services from those of other entities. A trademark is a device which can take almost any form as long as it is capable of identifying and distinguishing specific goods or services. A trademark is typically a name, word, phrase, logo, symbol, design, image, sound, or a combination of these elements. There is also a range of non-conventional trademark comprising which do not fall into these standard categories, may therefore be visible sign, example color, shapes, moving images, holograms, positions, non-visible signs, etc. So you mostly see that how mediation works in trademark, that is the term intellectual property rights has not been defined under any Indian statute. As per the World Intellectual Property Organization, that is WIPO, intellectual property refers to creation of the mind, such as inventions, literary and artistic works, designs, and symbols name. and images used in commerce. Trademark is a type of intellectual property right. The role of mediation in case of trademark dispute has been increasing over the years because of the importance of companies place on their trademarks and the unique protection offered. For example, I make an image with a background sound for my company. Now somebody uses the same image and a similar, that is deceptively similar, which gives an impression to the consumers or buyers that that is my company only. So in such cases, when my company already has a very big goodwill and reputation, and if I will sue the small business, it will obviously get out of the path and it will be destroyed. So in such cases, mediation plays a very vital role, so that both the companies, that is my big giant company and the other upcoming company, can survive this animosity and can coexist in this environment. Let's go ahead. Companies who wish to either build a consumer base and reputation or protect their existing consumer base and reputation look for ways to establish and secure their trademarks. The trademark owner generally have two cause of action, that is an infringement and passing off. Usually the owners go to the civil court for permanent and temporary injunctions. This process usually takes years. This problem was realized soon, and in the year 2009, Section 89 was inserted in Civil Procedure Code 1908, wherein the court was given the power to refer a matter to arbitration, that is ADR process, arbitration, conciliation, or mediation, where the court feels that there is a possibility of settling the matter amicably. In the 129th Law Commission report has made a recommendation to make mediation obligatory for dispute settlement. This was considered as a landmark step in a positive move towards adopting alternative dispute resolution mechanism for resolving IPR disputes, and in order to deal with overwhelming backlog, the Controller General of Patent Design and Trademark, in collaboration with Delhi Legal Service Authority, had referred around 500 pending oppositions and rectifications in the trademark registry to mediation and conciliation. Another important step taken was that mediation of IPR disputes was introduced in Section 12A in the Commercial Courts Act of 2015, via Chapter 3A of the Commercial Courts, that is, Commercial Division and Commercial Appellate Division of High Courts. Let's come to landmark cases, and with this we will end the session for today. That is, in Salem Advocate Bar Association versus Union of India, the Supreme Court gave the meaning and extent of mediation. It also led to formulation of the model civil procedure mediation rules, and such rules were to be framed by the high courts. In the case of Vardhaman Rice and General Mills versus Amar Singh Chalwal, Supreme Court has emphasized on the needs of speedy disposal of cases relating to intellectual property, and hearing of the suit in such matters. It should proceed on day-to-day basis, and the final judgment should be given normally within 4 months from the date of the filing of the suit. So keeping these kind of limitation which we have set for IPR cases, keeping in mind the gravity of the offense or any dispute that has occurred, mediation helps a lot in such process. So we, with this, we come towards the end, and I am open to questions if there are any.
Our words may not be capable of communicating our sense of gratitude to you. Thank you so much, ma'am, for enlightening us. Ma'am, am I audible?
Yes, yes, you are audible.
So with this, we have reached our Q&A session. We already have some questions, and I request all the attendees to please type their question in the comment box. Ma'am, the question we have is there any category of mediation in India?
See,
More category?
mediation is a court referred mediation, that is section 89 of CPC that we have. which we normally practice in India. But if we are not going for litigation, then we don't have the doors of mediation open. So, in order to boost private mediation, we have to work towards this field.
Okay, ma'am. Ma'am, the very next question is from Aarti. Aarti is asking how long the process of mediation takes.
Actually, there is not a set time frame in which mediation takes place. There are 2 to 3 first sittings of mediation are important, but after the third sitting, if we see that the parties are still rigid and they are not willing to go and be flexible for the settlement process, then we ultimately refer it back to litigation.
Okay, ma'am. Ma'am, next question is from Puneet Kumar. He is asking how mediators are appointed. What is the criteria?
Okay, I have already discussed this that if you want to be a court appointed mediator, then it is a 10-year of practice which is required. That means that very senior advocates who have experience in the field of litigation are appointed by the court as mediators, and they also take 48 hours continuous practice before being appointed as a mediator.
All right, ma'am. Ma'am, next question is from Chavi. Chavi is asking how could we make people aware of mediation in remote areas or in villages about the
Actually, yeah, mediation is an upcoming field and it will take time for people to accept it. That because any change which is coming is get its acceptance gradually. So, we are working in the field of legal aid. Now, legal aid is also one of the paralegal field of ADR. So with legal aid only, if we see say and start guiding people कि okay आपको कोर्ट नहीं जाना है, तो आपके पास ये मेथड भी है कि आप नेगोशिएशन की तरफ चले जाएं, आप आर्बिट्रेशन कंसिलिएशन की तरफ चले जाएं. So this is how with the process of legal aid only this can be collaborated and then presented to people that okay these are also ways out if you don't want to really go to litigation or court.
All right, ma'am. Ma'am, next question we have is from Upasna. Upasna is asking what are the drawbacks in present mediation system and how we can overcome it.
Yeah, so the biggest, according to me, the drawback is that you are getting the option of mediation once you have filed the case in litigation. That the court refers that, okay, now you go for mediation. If mediation or private mediation becomes the first stage, that if there is a check bounce case, for example, now I have to already file a criminal complaint for it, section 138, then I will be going for mediation. So why not once the check bounce is already there that has happened, I go for mediation directly. There will be one less criminal case. And if you see negotiable instrument, especially the check bounce case, there is very weak criminal intent involved in that. So I think these kind of cases should be first referred to mediation before filing even a case for litigation.
All right, yes, ma'am. Ma'am, next question we have is what are the major obstacles a mediator faces during a mediation?
Okay, so sometimes parties feel that mediator can guide them in a better way or give legal advice. On the other hand, mediators are not allowed to give any legal advices. They are only there to guide the process. So sometimes we have to deal with the emotional part that parties are willing or they are looking to us for legal advices, but we cannot do that. Plus, if we are not somewhere, there is a lot of feminism in today's world. So I think that if any lawyer is not gender neutral female lawyer or she is very feminist, then also it can hinder the mediation process because then she will be favoring the woman only blindly. So these are some the personal shortcomings of the mediators can really affect the mediation process. So one has to keep their shortcomings, their beliefs at the back and just focus on the case which is in front of them.
Thank you, ma'am. Ma'am, next question is by Shagun Agarwal. Shagun is asking, what do you say about future of mediation in India as an alternative to litigation process?
Actually, it
Alternate.
is. no more an alternative method, but it is now becoming a parallel method to litigation, because we have seen that there have not been very heavy litigation in this one entire year of 2020. So I think once people have realized that litigation is not that important for the legal conflict, so I think major parties will now go towards alternative dispute method, because it not only saves time, money, but it also saves a lot of resources. And if we go for the establishing of better institutions for them, then I think they will give amazing results.
Okay, thank you, ma'am. Ma'am, the next question is by Smeeksha Hans. Smeeksha is asking, ma'am, in case of negotiation, you said we mainly focus on the money matters and not on mediation. Ma'am, what does it mean that no talk of money in mediation? Kindly throw some light on it.
No, it's not like that, money matters are not for mediation, but as the name suggests, negotiation. So you have to negotiate in a manner where it happens to be a money matter. I'll just show that. For example, if you see the process of negotiation, it is designed as such that it is for commercial matters. So when you talk about commercial matters, then it has to be related to contracts and money related matter, or maybe goods. So it is more of a commercial nature, out of court settlement.
Okay, ma'am, last but not the least, we have last question. Is there any code of conduct for mediators or they act independently?
No, if they are court appointed, like Delhi High Court appoints mediators, so they are answerable to the court, uh, that whatever contract or the settlement they ask the parties to frame, so they are answerable to the court if the settlement is not drawn well and it is not legally sound. So, and private mediation is still not very prevalent in India.
Right, ma'am. Thank you so much, ma'am. With this, we have reached our end of the session, and I request the chairman of Social Cure, Mr. Pulkit Joshi, to give a vote of thanks.
Good afternoon to one and all. On this wonderful afternoon today, I would like to present the vote of thanks to all our attendees for the webinar. I would like to take this opportunity to thank our guest speaker for today, Advocate Smeeksha Pandey, for this wonderful webinar today. Uh, there would not have been more appropriate person than ma'am to embellish, to enhance, to enlighten, and to enrich the event. Thank you very much, ma'am. My special and heartfelt thanks to all the volunteers of Team Social Cure for glorifying this session. Once again, my sincere thanks to one and all. Be safe, be aware. I would further request all the participants to kindly type their name and email address in the chat section of the YouTube live. Thank you very much.
Thank you so much. It was a pleasure to be here.